My lord, this is a habeas corpus petition on the last occasion. The issue which came up before this court was with regard to the maintainability of this instant petition, fact being that the detention is through a court's order, and whether a writ of habeas corpus can be issued against a detention which is through a court's order. That is the moot question, my lord. So, my lord, I have gone through, my lord. I have also tried to find out whether such similar situation is there, but no similar situation could be found. But the principle is that a writ of habeas corpus can be issued when a detention is by a court order, but there are certain conditions. The detention order, the court, before issuing a writ of habeas corpus against a court order, the court has to held that the detention order which is passed is without jurisdiction, or is absolute illegality, or has been passed in mechanical manner or in casual manner. If these conditions are satisfied.
No, Mr. Khan, you see, when we normally speak of a detention order, first which comes to the mind is detention order under NSA, detention order under the PTS and NDPS Act. Those are done by the authorities. But here what has happened, that has been ratified by the court.
My lord, we will not say detention order.
Judicial order, because against a judicial order, you have a remedy of revision or appeal. But insofar as the normal detention orders are concerned, passed by the authorities, you have a what you call a committee to or a administrative body to look into it, and then the court is the only remedy available.
My lord, I'll refer it to as an order only, my lord, not because I'll place some judgments. Yeah, Supreme Court. My lord, I have brought only 3 judgments. One is by the two judge bench of the Supreme Court. One is by the 2 judge bench of Patna High Court, and one by the 2 judge bench of Delhi High Court. Only 3 judgments I will place. Supreme Court decision. First Supreme Court. 2013 1 SCC 314. It is Manubhai Ratilal Patel versus the state of Gujarat and others. Kindly come to para 31, my lord. The principle is there, my lord. Para 31. Now, my lord, C, my lord. A, B, C, my lord, right hand side, the C column, my lord. It is well accepted. Lordship have got.
Yes, please continue. Please continue.
It is well accepted principle that a writ of habeas corpus is not to be entertained when a person is committed to judicial custody or police custody by the competent court by an order which prima facie does not appear to be without jurisdiction or passed in an absolute mechanical or wholly illegal. So, my lord, this condition that prima facie it has to appear to be illegal without jurisdiction or passed in a mechanical manner and wholly illegal. If this condition is satisfied, then this writ can be issued, my lord. Now, reading further, my lord, as has been stated in B. Ramachandra Rao and Kanu Sanyal, the court is required to scrutinize the legality or otherwise of the order of detention which has been passed, unless the court is satisfied that the person has been committed to jail custody by virtue of an order that suffers from the vice of lack of jurisdiction or absolute illegality, a writ of habeas corpus cannot be granted. But, my lord, if these are satisfied, then it can be granted. That is the principle. Now, my lord, I will place another 2 judgments, my lord. Already copy has. My lord, I am placing Delhi High Court 2 judge bench, my lord. That is Nitin Garg versus Union of India and others. Kindly come to para 21. Para 21.
Just a moment. I've seen the decision after a long time. I forgot the context. This case of Manubhai Ratilal Patel. You see page para 21. How do you reconcile this with your previous argument made on the last date?
Para 21, my lord. The principle laid down in Kanu Sanyal thus is that any infirmity in the detention of the petitioner at the initial stage cannot invalidate the subsequent detention, and the same has to be judged on its own merit.
Because last time you made a submission, your entire edifice on the last date was that the initial order was, initial arrest and detention was bad. And therefore, the court, it validated the illegal order and then put him into custody. That's what your argument was.
My lord.
No, it's not that. I'm just trying to ask you, how do you reconcile your previous argument with para 21 here?
The later part of the order, my lord, validating the detention is also illegal, because at best that is under section 309. But on that day, the accused was not produced before the court. Accused was remanded to a, I'll go through the order, my lord. By the previous order, accused was supposed remanded to till 18th of that month. Under section, suppose 309, which is illegal. That cannot be validated, my lord, without bringing the accused to the court. Without bringing him, again he was remanded, suppose till 24th. That cannot be done, my lord. If court has to remand him, my lord, it has to be a proper remand. Accused is in jail, write some remand order, which we are saying is illegal, without producing the accused before the court on that day, without letting him know that you are being remanded till next date, my lord, that is illegal, my lord. Any remand by the court has to be in the presence of the accused. Any remand, my lord. If it is after 15 days or on the day of arrest, accused has to be before the court. The accused person does not even know he is being remanded under 309 on dated so and so while rejecting the bail prayer, my lord. That itself is illegal, my lord. Fact being that accused was not before the court. So, my lord, place another two judgments, my lord. There. My lord, I am placing the Delhi High Court, my lord, Nitin Garg versus the Union of India and others, my lord. Para 21. Analysis and findings. Para 21, my lord. Taking note of the submissions which were made at length, pertinently a writ of habeas corpus is an extraordinary remedy where there is illegal confinement violating the personal liberty of a person. Ordinarily, an order of remand by a competent court is essentially a judicial function and cannot be challenged by way of writ of habeas corpus unless and until the remand order lacks jurisdiction or is absolutely illegal, resulting in unlawful custody. It is true that an order of remand can be challenged in a habeas corpus petition if such an order is passed in an absolutely mechanical and casual manner. But this is in my favor, my lord. And my lord, I will just immediately place, my lord, quickly place the Patna High Court, my lord. That is Manoj Kumar Ladha versus CBI. Para 17, my lord. Paragraph 17. In the light of the question that has arisen as to whether the learned special court CBI 1 has passed the order in a mechanical manner and therefore the petitioner is entitled to issuance of a writ in the nature of habeas corpus. So it is held here also, my lord, that if it is in a mechanical manner, it can be issued. Now, para 18, my lord, quickly, my lord. It is evident on bare reading of the order dated 26/10/22 that the same was not passed in a mechanical manner, rather with due application of mind. So, my lord, the court has reproduced the order and have applied its mind that whether this order is without any authority or in a mechanical manner. And a para 18, my lord, the court have held that no, this is not mechanical manner. So, my lord, my humble prayer before your lordship is that lordship may kindly peruse the order, my lord, which we have impugned in this case, and this court may kindly scrutinize whether that order is mechanical, illegal, passed in a casual manner or not. If yes, then a writ of habeas corpus will lie. If no, if the answer is in negative and this court holds that no, this order is proper, it is not in a mechanical manner, then the writ of habeas corpus cannot be issued. It is simple.